Sorry, Hoosiers, technology failed me there. After the intro, I grazed a button on the computer and it stopped recording. So I'm not exactly sure how I'm going to get that first part in. It may have to be downloaded in 2 parts. Again, sorry about that. So then we'll move on. Let's see, how do I usually go about this? Oh, yeah. Do not despair, Hoosiers. There is a solution. The Constitution solution. Hello, I'm Dr. Chris McGarrah from Warsaw, Indiana, with yet another episode of The Constitution Solution. So we've been over the Indiana Constitution and commentaries on it. But one thing I think is important to talk about is to summarize the constitutional powers of the governor. How many of you out there have been concerned with the actions of our king? I mean governor. I have been concerned. Well, when in doubt, go back to the Constitution. So, that's what I'm going to do. And this is the 1851 Constitution with its various amendments. Okay. Let me get into this. All right. A little background first. Let's go back to Article 3, Section 1, the distribution of powers. And I read here, the powers of the government are divided into 3 separate departments: the legislative, the executive, including the administrative, and the judicial. And no person charged with official duties under one of these departments shall exercise any of the functions of another except as in this Constitution expressly provided. And remember, the legislative branch is responsible for all laws. I can read that part. I'll just do that. Article 4, Section 1. The legislative authority of the state shall be vested in a General Assembly, which shall consist of a Senate and a House of Representatives. The legislative authority of the state shall be vested in a General Assembly. Okay. Now, when talking about constitutions in the 3 branches of government, there is, as a direct corollary of the distribution and separation of powers, something called the Principle of Non-Delegation. Now, that's not specifically in the Constitution, but it follows from what's called the rules of construction, how contracts were put together back in the 1700s and 1800s, according to legal standards. Now, the principle of non-delegation means that one branch cannot delegate its authority to another branch. They can't, unless, of course, you specify so in the Constitution as an amendment or part of the original Constitution. Now, how this has been abused over the years by the legislatures. Let me give you an example of, say, our federal legislature. And let's pick on, for a moment, the Clean Air Act. The Clean Air Act. So what Congress is famous for doing, and they've evolved this technique over 100 and some, now 200 and some years, but when they first started doing this, the Constitution was actually very new. So, but with the Clean Air Act, what the Congress said basically was, we like clean air. We think clean air is a good thing. Here's kind of a general bill. Mr. President, the chief executive, and the administrative state, you figure out the details. That's basically what they said. And so what happens when they do that? Well, first of all, that's a violation of the non-delegation principle. But there's a method to the madness. And I call it the coward's principle. Congress is afraid. The Indiana state legislature is afraid to put its name, reputation, and votes on specific laws and rules. So they push it off on the president, or in our case, the governor, and say, you do it. Now, the cleverness behind that is, if things work out great, then the Congress or the General Assembly takes credit. So in the case of the Clean Air Act, the Congress says, okay, hey, we got clean air. We did it, yeah. But when the EPA now becomes oppressive, tyrannical, dictatorial, then the Congress can say to the people, oh, that's the fault of the administrative state. That we didn't say that. They're evil. That's the evil administrative state, the evil president. We need to fix this. So the Congress then can take credit for the good things, and they can assign blame for the bad things. All the while, their hands are clean. They've never had to go on record. So, when you see our governor doing things that appear to be and are carrying the force of law and making law, and in even some cases acting in a judicial fashion with his executive departments, just think about how it violates the separation of branches, the separation of powers, and the principle of non-delegation. So what I'm going to do for you now is go through all the constitutionally specified powers of the governor of Indiana as of the amended 1851 Constitution. And I counted them up to be 23 powers. Well, let's get to it, Hoosiers. Power number 1. This is in Article 4, Section 9. Okay, sessions of the General Assembly. But if in the opinion of the governor, the public welfare shall require it, he may at any time by proclamation call a special session. The length and frequency of the sessions of the General Assembly shall be fixed by law. Power number 1 of the Indiana governor, as set forth in the Constitution. Now we go on to Article 5, the executive branch. There's quite a few powers here, as you can imagine. Okay. Power number 2 is in Section 10B. Whenever there is a vacancy in the office of lieutenant governor, the governor shall nominate a lieutenant governor who shall take office upon confirmation by a majority vote in each house of the General Assembly and hold office for the unexpired term of the previous lieutenant governor. But the thing is, the governor shall nominate the new lieutenant governor. Okay, power number 2. If the General Assembly is not in session, the governor shall call it into special session and to receive and act upon the governor's nomination. So that would be power number 3. Okay, power number 4. This has to do, I'm not sure this is really a power, but it's a procedure to be followed by the governor. I guess you call it a power in case there's a question of the fitness to be in office. Subsection C of Section 10, Article 5. Whenever the governor transmits to the president pro tempore of the Senate and the Speaker of the House of Representatives the governor's written declaration that the governor is unable to discharge the powers and duties of the office, and until the governor transmits to them a written declaration to the contrary, such powers and duties shall be discharged by the lieutenant governor as acting governor. Then when the governor transmits to the same people a declaration that no inability to carry out the duties exists, the governor shall resume the powers. Okay, we go on here. Now, the Senate and House can file with the Supreme Court that they feel the governor is able to discharge the powers, and then there's a sub-power here of the governor. It says, thereafter, when the governor files with the Supreme Court the governor's written declaration that no inability exists, the Supreme Court shall meet within 48 hours to decide whether such be the case, and such decision shall be final. Okay, so that's powers 2, 3, and 4 of the governor. We'll go on to power number 5 in Section 12. The governor shall be commander-in-chief of the armed forces and may call out such forces to execute the laws or to suppress insurrection or to repel invasion. Those are actually kind of important things to notice when it comes to the Emergency Powers Act, which is a whole different kettle of fish, so to speak. The governor shall be commander-in-chief of the armed forces and may call out such forces to execute the laws. But remember, the laws must be in pursuance of the Constitution. Or to suppress insurrection or to repel invasion. Not seeing anything here about viral infections. Unless you consider the CCP virus an invasion. Well, let's not go there. Okay. Power number 6, Section 13. The governor shall, from time to time, give to the General Assembly information touching the condition of the state and recommend such measures as he shall judge to be expedient. That was power number 6. Power number 7. I think I may have missed one here. The governor shall have 7 days after the day of presentation to act upon a bill as follows. He may sign it, in which event it shall become law. He may veto it. Okay, we'll just consider all this power number 7. This is about how he signs off on bills. If the governor does not return the bill within 7 days of the presentment, the bill becomes a law notwithstanding the veto. The governor returns the bill under Clause A. The House, in which the bill originated shall enter the governor's objection at large upon his journals and proceed to reconsider and vote upon whether to approve the bill. So that's how the veto process works. Okay. There's a couple more things in here about the governor may or may not sign it and when it does or does not become law. But we'll just group that all under power number 7 about the signing or vetoing of bills. Power number 8, section 15. The governor shall transact all necessary business with the officers of government and may require information in writing from the officers of the administrative department upon any subject relating to the duties of their respective offices. Power number 9, section 16. The governor shall take care that the laws are faithfully executed. This one's kind of important. The governor shall take care that the laws are faithfully executed. Now, once again, if laws are not made in pursuance of the Constitution, they are null and void. That's a little bit of a different subject there, but that's the power of the governor. Carry out the laws faithfully. Power number 10. The governor may grant reprieves, commutations, and pardons after conviction for all offenses except treason and cases of impeachment, subject to such regulations as may be provided by law. Number 11 power. Upon conviction for treason, the governor may suspend the execution of sentence until the case has been reported to the General Assembly at its next meeting, when the General Assembly shall either grant a pardon, commute the sentence, direct the execution of the sentence, or grant a further reprieve. The governor may remit fines and forfeitures under such regulations as may be provided by law, and shall report to the General Assembly at its next meeting each case of reprieve, commutation, or pardon granted, and the names of all persons in whose favor remission of fines and forfeitures were made, and the amounts remitted, provided, however, the General Assembly may, by law, constitute a council composed of officers of state, without whose advice and consent the governor may not grant pardons in any case except those left to his sole power by law. So what I see here is that the legislature in this one, on that power, they kind of took some power away or put a cap or a regulation on him. Now we'll go to Power 12, Section 18. This has to do with vacancies in judicial. The governor shall fill such vacancy by appointment, which shall expire when a successor shall have been elected and qualified. That's in any state office. Any state office. Okay, power number 13. Oh, yes, power number 13. Section 20. Should the seat of government become dangerous from disease or a common enemy, the governor may convene the General Assembly at any other place. Should the seat of government become dangerous from disease or a common enemy, the governor may convene the General Assembly at any other place. Power number 13 of the governor in the Constitution. Okay, we're on Article 6 now, administrative. I find power number 14. These are kind of maybe powers because while it doesn't specifically say governor, it says whatever it says in law who appoints these people, and in those codes, it may be the governor, it may not be the governor, but I'm going to count it as a potential gubernatorial power. Section 3, Article 6, administrative. Such other county and township officers as may be necessary shall be elected or appointed in such a manner as may be prescribed by law. I'm not sure that all the code, Indiana code, allows or specifies the governor to do any of these county and township things, but it's possible. So we'll count that as potential power 14. Here we go, power number 15, again, potential. Section 9 of that article, vacancies in county, township, and town offices shall be filled in such a manner as may be prescribed by law. And again, I only say this might be a power of the governor if in that part of the code for counties, townships, and towns, it says the governor appoints these people for vacancies. Might or might not, but we'll count it as power number 15. Now we go on to Article 7, Judicial, Section 9. This talks about the Judicial Nominating Commission. We went over that when I made the presentation on that article. Come down here to Section 9, about midway through. Power 16. The governor shall appoint to the commission 3 citizens not admitted to the practice of law. So the commission has 7 members. One is the Chief Justice, then 3 members who, this is interesting, and we went over this before. Those admitted to the practice of law shall elect 3 of their members to serve as members of said commission. So all the lawyers in the state get together and vote for 3 members of this commission that picks, gives lists of suggestions and picks nominees for Judicial Nominating Commission. And then the governor picks 3, if you will, non-lawyers, civilians, and then there's the Chief Justice. So whether or not that's a good thing, we debated before, but that's power 16 of the governor to make those appointments. Power 17, Section 10 of Judicial. Selection of justices of the Supreme Court and judges of the Court of Appeals. A vacancy in a judicial office in the Supreme Court or Court of Appeals shall be filled by the governor without regard to political affiliation from a list of 3 nominees presented to him by the Judicial Nominating Commission. If the governor shall fail to make an appointment from the list within 60 days from the day it is presented to him, the appointment shall be made by the Chief Justice or the acting Chief Justice from the same list. So that's power 17 of the governor. Okay, we go on to power number 18 is found in, the wonderful and controversial Article 8, Education. Section 8. There shall be a state superintendent of public instruction whose method of selection, tenure, duties, and compensation shall be prescribed by law. And I believe that in 2017 there was a law making the state superintendent of public instruction an appointed position by the governor and not an elected position. That's power 18 of the governor to appoint the state superintendent of public instruction. Okay, we move on. Power number 19 under Article 12, Militia. The governor is commander-in-chief of the militia and other military forces of this state. Period. The governor is commander-in-chief of the militia and other military forces of this state. That's power number 19. Power 20. there shall be an adjutant general who shall be appointed by the governor. Pretty straightforward. Okay, we're coming down to home stretch here, folks. Power 21, miscellaneous Article 15. All officers whose appointment is not otherwise provided for in this Constitution shall be chosen in a manner as now is or hereafter may be prescribed by law. So again, that's a potential power of the governor if the law, as in the Indiana Code, for those officers states that the governor appoints them. And again, I don't know how many there are of that. That would be in the code. But it's potential power number 21. Power number 22, Section 2 of Article 15. When the duration of any office is not provided for in this Constitution, it may be declared by law, and if not so declared, such office shall be held during the pleasure of the authority making the appointment. The pleasure of the authority making the appointment. So in other words, if it is specified that the governor can appoint or shall appoint or may appoint some particular officer of the state government, then according to this, unless it's otherwise stated by law, the governor can fire that person or ask for their resignation to be tendered. So, power number 22. Power number 23. All commissions shall be issued, all commissions shall issue in the name of the state, shall be signed by the governor, sealed with the state seal, and attested by the Secretary of State. The commission means as in commissioning officers of the state. So the governor has to sign it. That's a power of the governor. Well, that's it. That's it, folks. The 23 powers of the governor as enumerated and specified in the Indiana Constitution. So, when it comes to the next gubernatorial election in 2024, I believe, if I've calculated correctly, this will be an open seat because our current governor is termed out. Of course, this is Indiana. Anything can happen. But you need to keep in mind, and I'd like you to save this recording and review it, so that when candidates start coming forth for the 2024 election to governor, you grill the heck out of them on, are they going to only stick to the 23 powers specified in the Constitution? There are those that feel that the governor, our current governor, has exceeded these powers, or one might say usurped power under the guise of the Emergency Powers Act. Now, I read that, the whole thing, a couple of days ago, and I've got some big problems with it. Several parts of that are clearly going against provisions in this Indiana Constitution, so I have big problems with the entire Emergency Powers Act, and maybe I'll go over that in another episode. But again, remember what the founders said, and I believe it was George Washington in his farewell address that he said, "Let there be no change by usurpation. Let there be no change by usurpation. For though in one sense it may be for the good, it is the usual method by which free governments are destroyed." I didn't even have a teleprompter for that. I'm impressed. So remember old George. He's pretty wise guy. So just because it's Team Red, don't let them usurp power. And in fact, a lot of the founders felt that usurpation of power was treason. There's a whole episode of the 10th Amendment Center about that. It was recently. Well, in any case, let there be no change by usurpation. Because you know what that does? Just because it's your team, whether your team be Team Red or Team Blue, once you usurp a power, that becomes a precedent. And then look what happens. So you think it's good that Team Red usurps some power and does something you like? Well, now look where we are with Team Blue in the House, the Senate, and the presidency. And look at the abuses that are going on, acting under the guise of precedence. In other words, it's done before, so we can keep doing it. Precedence is a dangerous thing. So don't start one. Let there be no change by usurpation. Okay, I've taken up enough of your time, but I thought it was important to go over the 23 constitutional powers of the Indiana governor. So, here we are again. When I come back on the air is unclear. We're getting to the point where everyone needs to start mobilizing for the up-and-coming May 2022 primaries. We've got liberty-oriented candidates that need to come out. All of you people out there need to start supporting these candidates, going door-to-door action, educating the voters on the Constitution so that we can make a change and save Indiana. We don't have much time. It's what? 6 months. Time is now. Get to work. So, in conclusion, as always, remember to follow doctor's orders, wash your hands, don't touch your face, but above all, keep your distance. Keep your distance from those socialists, statists, globalists, collectivists, politicians, and bureaucrats, because now, Hoosiers, you know exactly who they are. The curtain has been pulled back. We need to drain the Indy swamp and send all of them back home, except Kurt Knisley, John Jacobs, maybe a few others. But by and large, with the exception of those two, everybody else needs to go home. And we need constitutional candidates. Remember the 3-question rule. Is it constitutional? Can we afford it? Do we need it? In that order. In that order, no excuses. You can't do that. You don't deserve to be in government. Well, Hoosiers, good night, and I'll see you at some point in the future when the time calls. All right, so remember, just don't know your constitutions. Live them every day. Thank you and good night.